On the day of your hearing, you must sign in on the record of attendance so that the board knows you are present. In most hearing locations, a security guard is at a table helping people sign in. If you are a tenant, you may wish to speak to Duty Counsel. Tenant Duty Counsel provides legal advice and is a free service for tenants. This service is provided by Legal Aid Ontario and not the Landlord and Tenant Board. Tenant Duty Counsel does not make appointments to speak with tenants, but sees tenants on the day of the hearing. They give priority to tenants with eviction hearings. If you're a small-scale landlord, you can call the Landlord Self-Help Center before your hearing. You can also talk to a board mediator before your hearing. Mediation is a process that helps landlords and tenants come to their own solution, but both parties have to agree to try it. Board mediators can help you and the other party talk about your tenancy problems and reach an agreement. Your hearing will be canceled if a mediated agreement is made that resolves the tenancy problems in your application. If you cannot come to an agreement, your hearing will generally proceed as scheduled that day, time permitting. There are usually many hearings scheduled in the same hearing room for the same start time, and they are all heard by one member. The member is in charge and will explain the rules of the hearing. You must treat the other parties with respect and courtesy and always follow the member's rules for the hearing. Hearings are open to the public unless a member decides that the matters to be discussed are too private and personal, and the hearing should be closed to the public. The member decides the order in which the applications will be heard. Your hearing may be the first or the last hearing, so you should not be late and you should be prepared to stay until your case is heard. When the member calls your case, they will call out your application number, your name, and the name of the other party. There are tables at the front of the hearing room. One table is for the applicant, and one is for the respondent. When your name is called, you go and sit at the appropriate table. At the hearing, the parties will each have an opportunity to give evidence and ask questions of the other side. Evidence can include what is said at the hearing, as well as the documents and photos that are presented. The applicant will start by explaining why they made the application. Then they will tell their side of the story and give any evidence they have. They may give evidence themselves or call witnesses to give evidence. The applicant gives the member and the respondent a copy of any documents and photographs that they have brought to the hearing. The member hearing the application will give the respondent the opportunity to ask questions about the evidence presented by the applicant and their witnesses. When the applicant is finished presenting their case, it is then the respondent's turn to tell their side of the story and present their evidence, give their documents and photos, and call their witnesses. The applicant can then ask the respondent questions. The member can question either party any time during the process. Afterwards, both parties sum up their case based on the evidence they have given. In some cases, the member will announce their decision at the end of the hearing, but in most cases, the member will tell the parties that they will send out their decision soon after the hearing. A member must give their decision in writing. The written decision of a member is called an order and is enforceable, just like an order of the court. The board will mail a copy of the order to you and the other parties to the application. In summary, if you and the other party can't mediate an agreement about your tenancy problems, a member will hear your application and issue an order that sets out their decision.